This is Barry Zalma on insurance. Today it's time to speak about how to defeat insurance fraud. Insurance fraud is a crime in most states of the United States. The victims of the crime of insurance fraud are insurers, no one else. The crime is committed by every race, gender, national origin, religion, or sexual orientation. The crime of insurance fraud takes from the insurance industry and, as a result, the insurance buying public anywhere from $80 to $300 billion every year. No one knows the real amount because most insurance fraud attempts succeed. Unlike other victims of crime, state legislatures require insurers to create special investigative units, SIUs, to thoroughly investigate all potential insurance fraud and present evidence to the authorities so that they can prosecute insurance fraud. Unfortunately, experience of the insurance industry has established that even when the insurer's SIU presents a case to the state's fraud division or fraud bureau for criminal prosecution, it is rare that a prosecution is commenced, and even rarer a conviction obtained. State insurance departments brag about convictions in double digits when they receive as many as 1,500 reports of suspected fraudulent claims every 30 days. Prosecutors dislike insurance fraud cases because they're usually document-heavy, while an assault, rape, murder, or drunk driving are usually summarized by a single police report and are therefore relatively easy to prosecute to a jury or obtain a plea of guilty. Some insurers are even now buying artificial intelligence software to detect insurance fraud. Others hire retired police officers to operate the SIU and ignore their experienced insurance claims handlers. Most do the minimum necessary to fulfill the requirements of the anti-fraud statutes and regulations, concluding that it is better and less expensive to pay the fraudsters than to fight fraud attempts proactively. Now, I propose that what an insurer must do to defeat insurance fraud is to work proactively. I have been involved in insurers' attempts to defeat or reduce insurance fraud for almost 54 years. I have seen fraud succeed. I have had clients compel settlement of fraudulent claims with voluminous evidence sufficient to prove the fraud beyond a preponderance of the evidence to avoid the possibility of having to defend a bad faith lawsuit. The only way, in my experience, to defeat insurance fraud is to take the profit out of the crime. Criminal prosecutions do not take the profit out of the crime. Since there are fewer arrests, fewer convictions, and most sentences, even after a conviction, are mild and often do not even require full restitution to the defrauded insurer. As a result, many insurers refuse to rely upon police agencies, even state insurance fraud divisions or insurance fraud bureaus, because of a lack of success of those agencies to reduce insurance fraud. Courageous insurers have decided to refuse to be victims of fraud. They refuse to pay. They take fraud cases to trial and appeal all adverse judgments. Some are beginning to take advantage of whistleblower provisions in state insurance fraud prevention acts, the so-called IFPAs. It is, in my opinion, essential that every insurer conduct a thorough investigation of a suspected insurance fraud, and move forward to determine whether or not the suspicion is provable as an actual attempt at insurance fraud. So what is a thorough investigation? Basic claims handling standards that I was taught as a young insurance claims trainee in 1967 that have existed for many decades before that required that every claim must be subjected to a thorough investigation. The claims investigation is performed by an adjuster, either an employee of the insurer or an independent contractor, conducting a thorough investigation that begins with a complete recorded statement from the insured and all witnesses to the incident that reportedly caused a loss. Although some insureds are uncomfortable with regard to giving a recorded statement, whether taken in person or over the telephone, the adjuster must take the time with the insured to make the insured comfortable with the procedure by establishing rapport with the insured and showing empathy for the insured's loss. When faced with recalcitrance from the insured, the case statement can be taken in person without a recorder, with the adjuster taking notes. The notes should then be converted into a statement, sent to the insured to be read, corrected, signed, and dated. In taking the recorded statement, the adjuster must get answers to the most important of all questions relating to the policy and the loss. Who, what, where, why, when, and how. If an old-fashioned tape recorder is used, the insured should be asked to sign or initial and date the case set and watch as you punch out the tab to prevent changes in the recording. If recorded digitally, the statement should be transcribed, set to the insured to read, correct, and sign. Recorded statements of neighbors, relatives, and vendors of the insured may also be useful in obtaining a complete picture of the loss, and should be obtained as soon as possible after completing the first meeting with the insured and obtaining the insured's recorded statement. The adjuster must always conduct a thorough investigation at the scene of the loss. He or she must establish the cause and origin of the loss. Was it a burglary, a fire, a theft, a vandalism? Obtain a general idea of the extent of the loss and what expert assistance will be required to complete the investigation and adjustment. It is prudent, after the first meeting with the insured, to canvass the neighborhood to determine if any neighbors are able to add any facts to the loss recitation itself, its cause, and its origin. When the loss is extensive, it is appropriate for the adjuster to retain the services of a salvor or inventory specialist to aid the insured in completing a thorough inventory, as well as a construction consultant to create a complete scope of loss, damage, and necessary repair. Failure to obtain an agreed scope of loss is evidence that the adjuster has failed to fulfill his or her obligation to complete a thorough investigation of a loss, and a violation of a major obligation imposed by the insurer on all of its adjusters to thoroughly investigate each claim fairly and in good faith. Sometimes, to complete a thorough investigation, it is necessary to require the insured to submit to an examination under oath, an EUO. The EUO is a tool used sparingly by insurers in the United States. It is only used when a thorough claims investigation raises questions about the application of the coverage to the facts of the loss, the potentiality that a fraud is being attempted, or even to just assist the insured in the obligation to prove to the insurer the cause and amount of loss. Although rarely used, the EUO is an important tool available to the insurer, its adjusters, and SIU investigators. Anyone designated by the insurer can take an EUO. Insurers recognize, however, that lawyers, whose profession is asking questions, will usually do a more thorough job at EUO than an insurance claims professional, adjuster, or SIU investigator. The lawyer can also, after completing an EUO, give the insurer legal advice as to its rights, duties, and obligations. If the thorough investigation conducted by the adjuster and/or SIU investigator establishes that the insured is not entitled to indemnity, it is incumbent on the adjuster and the insurer the adjuster represents to refuse to settle and be ready to defend aggressively a lawsuit from the insured, who, of course, will be unhappy that his claim has not been paid. It is an essential part of a thorough claims investigation to determine the accuracy of the statements made by the insured in the application for insurance. However, even if investigation reveals false statements on the application, a thorough investigation of a claim should never stop with determination that the application contains false information. The broker or agent who took the application from the insured must be interviewed, and copies of the broker's file or agent's file obtained and analyzed, because it is almost certain that a person confronted with a misrepresentation on the application for insurance will say, "I told the truth to my agent. I don't know why the application says something different." The thorough investigation must determine whether the false statements were actually made by the insured and that the agent or broker did not act creatively to make the insurance a risk an underwriter was willing to take. There's, for example, in O'Donnell v. Allstate, a 1999 decision of a Pennsylvania appellate court, the following red flags were found to be a reason for an insurer to suspect arson for profit. 1. More than one mortgage. 2. Late payments. 3. Divorce. 4. Prior claims. 5. Multiple claims. 6. Problems affecting title to the property. 7. Overinsurance. 8. An increase in insurance coverage right before the claim. 9. Recent cancellations of insurance held with prior insurers. 10. Liens. 11. Threats of foreclosure on the property. 12. Lawsuits. And 13. Recent job transfers. As the Nebraska Department of Insurance states in its booklet, Fraud Detection Hints, it is important to remember that the possible red flags that may be some evidence consistent with an insurance fraud scheme, any one of which by themselves may not raise suspicions. However, when there are several of these red flags present or a pattern begins to emerge, the adjuster should investigate further or forward the suspicion to the insurance company's SIU or to the state's Insurance Fraud Prevention Division. The test for all investigators dealing with potential fraud is when one or more red flags exist that cause the investigator or claims person to decide that further investigation is required, must pursue that investigation with the professional fraud investigators in the company's SIU or in the state's fraud division. For example, California Code of Regulations describe a thorough investigation at Section 2698.36 of the California Codes of Regulations, called Investigating Suspected Insurance Fraud, and explains what is required to complete a thorough investigation. The regulation, therefore, explains that an SIU must establish, maintain, distribute, and adhere to written procedures for the investigation of possible suspected insurance fraud. And an investigation of possible suspected insurance fraud shall include, at the very least, a thorough analysis of a claim file, application, or insurance transaction, identification and interviews of potential witnesses who may provide information on the accuracy of the claim or application, utilizing industry recognized databases, preservation of documents and other evidence, writing a concise and complete summary of the investigation, including the investigator's findings regarding the suspected insurance fraud and the basis for their findings. In addition, to complete a thorough investigation of a suspected fraudulent claim, the adjuster or SIU investigator must provide detailed recorded statements of the insured and all independent witnesses, a demand for production of all documents available to the insured relating to the loss, such as title documents, purchase documents such as receipts, purchase orders, purchase contracts, invoices, warranties, credit card statements, and the like, telephone records, tax returns, employment records, repair invoices, repair estimates, replacement estimates, and an examination under oath of the insured, an examination under oath of any partners, employees, or officers of a suspected corporation or partnership, reports of any relevant experts like a fire cause and origin expert or a structural engineer, advice and counsel from an independent insurance coverage lawyer. Now, some IFPAs, like the California IFPA, sets up a potential solution to insurance fraud by use of a qui tam, or whistleblower statute. In a case of amazing and surprising, to me anyway, perspicacity, the California legislature recognized the problem of insurance fraud and lack of sufficient prosecution, and added to the California Insurance Fraud Prevention Act a qui tam provision that made it possible for insurers to file whistleblower suits against fraud perpetrators. The law is unique because the law allows individuals to sue on behalf of private insurance companies and for insurers to sue fraud perpetrators in the name of the state of California. Additionally, if the case is successful, the individual who brought the lawsuit receives a portion of the recovery. If the insurer reports hundreds of suspected fraudulent claims to a Department of Insurance like California's Fraud Division, it's left only with the following options. 1. Pay the fraudster what he or she demands. 2. Refuse to pay the fraudster and be ready to expend the effort and money needed to defeat the fraudster's breach of contract and bad faith lawsuit. 3. File a suit for declaratory relief seeking confirmation by the court that the insured perpetrated a fraud and is not entitled to any benefits of the insurance policy. 4. Be ready to defend a cross-claim for bad faith by the fraudster's lawyers. File a qui tam action under Section 1871.7 of the California Insurance Code that provides the insurer with the right to sue the fraud perpetrator and gain all kinds of penalties for the state of California, who is then obligated, once it collects those penalties, to share its collection with the insurer who brought the suit. This action takes the money away from the fraud perpetrator. And when you make it difficult and expensive for a fraud perpetrator to commit fraud, he will give up and go to someone who makes it easier. The insurer who has collected sufficient evidence to establish beyond a preponderance of the available evidence that it was the victim of a single or multiple acts of insurance fraud may file suit under the statute. The punishment, if successful, will be enormous, and the state and the insurer will share in the funds obtained. The False Claims Act, the Federal False Claims Act, also known as the Lincoln Law, dates back to the Civil War. President Lincoln signed the act into law in 1863 because war profiteers were selling the Union Army shoddy supplies at inflated prices. The original law included qui tam provisions that allowed a private person, a plaintiff, to sue those who defrauded the federal government. If the suit was successful, the plaintiff would receive 50% of any recovery from the defendant. Qui tam basically means who sues on behalf of the king as well as for himself, and there are a number of pronunciations, but the simplest is qui tam, which rhymes with ham. The False Claims Act makes it unlawful to knowingly present or cause to be presented to the United States a false or fraudulent claim for payment or approval, make or use a false record or statement material to a false or fraudulent claim, and use a false record or statement to conceal or decrease an obligation to pay money of the United States. And these qui tam provisions in the U.S. Code have been used successfully to defeat Medicare and Medicaid fraud across the country. Under the Act, private individuals, who are referred to as relators, may file civil actions on behalf of the United States to recover money that the government paid as a result of conduct forbidden under the Act. To establish a civil liability under the False Claims Act, a relator must prove, 1, that the defendant made a statement in order to receive money from the government, 2, that the statement was false, and 3, that the defendant knew the statement was false. The California legislature created the California IFPA to combat insurance fraud. When an insurance company brought a qui tam action to recover damages and fees occasioned by a surgical center's fraudulent billing practices, it did so in the name of the state, not the insurer. This powerful tool, used now by some insurers against multiple fraudsters, like doctors and treatment centers that give the exact same treatment to hundreds of insureds who are victims of insurance claims or are victims of accidents, take the money from the fraudsters, take the profit out of the crime, and those fraudsters will move on to other less prosecuted crimes, like taking benefits from the U.S. government efforts to ease the public's cost of the COVID-19 pandemic. Now, what can you do if there is no available qui tam statute? Every first-party property policy of insurance issued in the United States contains language that is adapted from the statutory New York Standard Fire Policy. Every state has a minor variation of the statute, but they all say the following, quote, "This entire policy shall be void if, whether before or after a loss, the insured has willfully concealed or misrepresented any material fact or circumstance concerning this insurance, or the subject thereof, or the interest of the insured therein, or in case of any fraud or false swearing by the insured relating thereto. If, after a thorough investigation of a claim, the insurer determines a fraud has been attempted, and the insurer has obtained a preponderance of all available evidence that can establish a fraud was attempted, the insurer must immediately, upon receiving that evidence, advise the insured it will not pay and will declare the policy void in accordance with the policy language I just quoted. The insurer must demand that every state create an insurance fraud unit in the state attorney general's office. The lawyer for the Department of Insurance of each state is the state's attorney general. A special unit could be established in the office of the attorney general, funded with the monies taken from the insurance industry to support the war against insurance fraud. This unit should be given a simple mandate: file and prosecute every insurance fraud brought to the unit by the fraud division that has a better than 50% chance of success. The unit should not concentrate its efforts on major insurance frauds. Those can best be prosecuted by major fraud units already existing in district attorneys' offices and in the offices of the U.S. Attorney. The state's unit should concentrate on prosecuting everyday insurance fraud, the frauds of opportunity that take 90% of the money paid to fraud perpetrators, in the range of $5,000 to $50,000 per claim. Single counts should be prosecuted. When prosecutors file multiple charges against individual defendants, the case becomes a major action requiring a great deal of time to prosecute. Judges and juries do not want to be involved in a prosecution that takes months to try. If there are multiple counts available, the prosecutor should charge only the one where the evidence of fraud is overwhelming. If the jury finds for the defendant, the prosecutor can charge the next count continuously until the statute of limitations run. If all available are charged in one case, the prosecutor will offend the judge and jury, and the defendant will get mercy from the jury. Overcharging prosecution is as bad as not charging at all. Today, a person perpetrating an insurance fraud need only be concerned that an aggressive fraud investigation might delay or reduce the amount that he might recover from his crime. Criminal prosecution for the crime of insurance fraud is so minuscule in relation to the amount of fraud as to be non-existent. It certainly has not acted as a deterrent. If the legislatures really want insurers to fight insurance fraud, if the legislatures wish to keep strong and viable this important industry, if the legislatures want to reduce the insurance premiums paid by their constituents, they must make practical the war on insurance fraud. As long as the tort of bad faith and the exposure to punitive damages hangs over insurance companies, the war will be one of attrition, where no one except maybe the fraud perpetrators will win. So I have the following proposal. Since it is often difficult to convince a state department of insurance, a state attorney general, or local prosecutors to prosecute insurance fraud perpetrators, insurers must proactively act to defeat insurance fraud. If there's no opportunity to file a qui tam action, the insurer must, as a corporate requirement, refuse to pay any insurance fraud perpetrator. Not a dime. The insurer who truly desires to defeat insurance fraud must, 1. require its entire staff of claims handlers be trained to recognize attempts at insurance fraud. 2. Require that the entire staff of claims handlers be trained to recognize the multiple red flags of fraud. 3. create, maintain, and effectively fund an SIU staffed with insurance and fraud-trained investigators. 4. Require a thorough investigation of every claim. 5. Require the claim staff to refer suspected insurance fraud attempts to the SIU when a claims investigation establishes no less than 3 red flags of fraud. 6. Require the SIU to conduct a thorough suspected fraud investigation on every claim referred to them by the claims department. 7. When the SIU collects what it believes to be evidence of an attempt at insurance fraud, it should refer, for advice and counsel, the claim to an experienced insurance coverage lawyer in the state where the claim was presented, as well as the required presentation of information of a suspected fraudulent claim to the state's Department of Insurance. And 8, if after review of the claims investigation, coverage counsel opines that there is a preponderance of evidence establishing a fraud was attempted and claims management is convinced the advice is proper, the claim must be rejected as a fraud. Once a suspected fraudulent claim is denied, 2 events will occur. First, the insured will accept the denial and try another insurer who is less aggressive, or second, the insured will sue for breach of contract and breach of the covenant of good faith and fair dealing, seeking contract tort and punitive damages. If the first option happens, the files are closed and nothing further is required other than a report to the Department of Insurance in accordance with the requirements of the state's IFPA. If the second option is chosen by the insurer must 1. Publish to the insurance buying public that it is the insurer's incorruptible opinion that it will never pay what it believes to be a fraudulent claim. 2. Retain counsel to defend the insurer. 3. Instruct defense counsel that the insurer expects counsel to take the matter to trial. No attempts at settlement will be considered. 4. Instruct defense counsel to aggressively defend the lawsuit. 5. Instruct defense counsel to conduct every needed discovery immediately and without courtesy to the other side. 6. Instruct defense counsel to depose every insured, every witness, and every expert consulted by the insured as soon as possible after the filing of the lawsuit. Do not act reactively to the plaintiff. Make the plaintiff act to your instructions. 7. Instruct defense counsel to move the trial court for orders limiting the actions of the plaintiff, including but not limited to motions for summary judgment, motions to compel discovery responses, motions in limine, and any other motion available to limit the evidence presented to the case by the insured and provide for the presentation of the most available evidence by the insurer. 8. Instruct defense counsel that he or she has no authority to settle or even consider negotiating a settlement. 9. Instruct defense counsel to advise the policyholder's counsel that the case must go to trial and there will be no settlement discussions. If ordered by a court to enter into settlement discussions, advise the court that it is the policy of the insurer to never pay a fraud and that it will offer zero regardless of the efforts of the court. 10. Instruct defense counsel to advise the court that because the insurer believes it was defrauded, it is against the insurer's corporate policy to pay anything to a fraud perpetrator. 11. Instruct defense counsel to provide no courtesy to the policyholder's counsel. And 12. If after trial there is an adverse judgment against the insurer, instruct counsel to immediately file an appeal. By so doing, a proactive insurer will establish proactively and spend millions to defend against fraud and refuse to pay tribute to anyone, especially to someone they believe to be a fraud perpetrator. Setting up such company policy will go a long way to reduce insurance fraud attempts against the insurer. Fraud perpetrators will move from that insurer to another. Those insurers who do not have such a corporate policy will find more attempts at insurance fraud and will be encouraged to take on the aggressive anti-fraud position taken by the insurer following what I have proposed to be the means to defeat insurance fraud. Thank you for your attention.